you very much. Some regulatory agencies like the FTC, the CPSC, OSHA, and the EPA have been saddled with so-called hybrid rulemaking statutes that require a more formalized process for issuing rules with hearing procedures and cross-examination requirements that are far more suited to adjudication than rulemaking. Dr. Michaels, you are a leading expert in the field and a constituent of mine that I'm very proud of. Do you think that these procedures should be removed in favor of the usual APA notice and comment rulemaking procedures that have been abandoned for these particular agencies and commissions?
Congressman Raskin, it's a great question and something that's very important that we should be looking at. I don't know about totally abandoning them because I think that hybrid procedure actually gets to some very important conclusions. In OSHA, we have a system where anybody who testifies at a hearing can cross-examine anyone else who testifies. So there's tremendous opportunity to gather evidentiary record. On the other hand, it takes a long time. So I'd like to think about, and I think we should all be thinking about ways to cut down the amount of time necessary to do this, to cut down the analytical requirements. The OSHA law says that OSHA has to show that every regulation is economically and technologically feasible in great detail. Okay. And as a result, it takes many years to issue a standard. The silica standard took 19 years.
Let me ask you, and I'll throw in Professor Wagner too here. Do you think that the current OIRA review process is cost effective and should be maintained as it is, given the added time that's taken for such review and given the growing criticism that OIRA primarily focuses on reducing regulatory costs rather than increasing regulatory benefits for social efficiency generally? Should OIRA really be assigned a different role than it currently has?
Yes, sir.
Yes, thank you. I sort of straddle the fence there, but I actually think that we wouldn't lose anything if we got rid of OIRA review. Currently, it's not only causing delays and leading to mysterious withdrawal rules, but OIRA is really getting in the details, including changing the science, overriding long, extensive regulatory processes, including expert peer review, and then literally changing the standards like it did in secondary ozone. Off the cuff, I am not sure we would lose anything by getting rid of OIRA review. The White House should be involved in agency decisions and should interact at some level. It's just not clear to me that it should be through this formalized, extremely controlling, very secretive OIRA review process.
Gotcha. And Dr. Michaels, what do you think?
I agree. I think OIRA can play a useful role. I don't think it should be eliminated. I think we do need an interagency review process, but the Stop Corporate Capture Act includes much more transparency, which in my testimony I address, which is really important. I also think it's worth noting that while OIRA really has been a conduit for special interests to be able to intervene secretly in regulations of the past, I think the current administration is working very hard to eliminate that and to expand OIRA's commitment to not just looking at costs and benefits, which are important, of course, but to looking at equity, justice, distributive effects, and pushing agencies to do that. And I think that's really a useful thing for them to do. Okay.
A lot of statutes are silent on the venue for judicial review of regulatory rules that are adopted. And under the APA, this means that rules governed by particular statutes are often subject to review in a district court chosen by the challenger, which delays the review and, of course, promotes forum shopping. Professor Wagner, since there's no need for an evidentiary hearing in such proceedings, nor for a two-stage review of such rules, would you agree with me that Congress should instead require that all judicial review of legislative rules go directly to the courts of appeal?
I think that's an excellent suggestion. The forum shopping that we've seen over the years leads to terrible inconsistency and lots of complicated district court rulings. So yes, I think that's an excellent idea.
You've written that the notice and comment process has become dominated by corporate interests and other highly resourced commenters. What can be done to address this problem? Is there any thought of having agencies provide assistance to applicants who don't have the same resources to participate in proceedings?
Thank you for that question. I definitely think we should think about subsidies and ombudsmen and proxies provided to major effective groups. As I mentioned in my oral and written testimony, I also think that Congress should simply create incentives for agencies to justify their decision-making processes from beginning to end, that they haven't considered and included all major groups, putting the burden on the agency.
Time of the gentleman has expired. Thank you.